Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 412 of the FCPA Compliance Report. Today, I have with me Philip Urofsky. Philip is a partner at Shearman Sterling, and he talks about the 2019 Shearman Sterling FCPA Digest. First, have you ever wanted to start a podcast but didn't have an idea of how to do so? Well, check in with a word from our sponsor, One Stone Creative.
If you are enjoying this show, you might enjoy hosting your own. As an expert in your field, you have skills, knowledge, and insight that can help you expand your practice, meet new people, and create amazing content to share with the world. In as little as 2 hours a week, you can dramatically change how you promote, fill, and position your business. And One Stone Creative can show you how. Learn more at onestonecreative.net.
In this podcast, I go into the highlights of the Shearman Sterling 2018 FCPA Digest, and Philip and I talk about the Hoskins decision, how it may impact FCPA enforcement and investigations going forward. It's a fascinating exploration of one of the year's annual top FCPA reviews, looking back and looking forward. I know you will enjoy it. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, and today you are in for a real treat because today I have with me Philip Urofsky. Philip is a partner at Shearman Sterling, and they have released one of the true gems of each year is the Shearman Sterling FCPA Digest. They've recently released a 2019 Digest, and it's chock full of everything you would want to know about the past year on FCPA. So, Philip, with that somewhat long-winded introduction, first of all, welcome and thank you for taking the time to visit with me.
You're welcome. Always a joy.
And once again, just thank you and the firm for putting this out. It's a resource that I have on my bookshelf every year, and I know a lot of compliance practitioners and lawyers do as well. So thank you and your firm for your incredible work on this.
Well, again, you're welcome. And before we get started, if I could just give a plug for our brand new FCPA website, which has the online digest, so you can search for cases as well as copies of the trends and patterns and other materials.
Well, great. We'll link to that in our show notes, Philip. I would say that this past year was unique in the FCPA world, but after about 12 years of practice in this area, I've finally come to the conclusion that every year stands on its own. So why don't we just start off with maybe looking at what were your or the firm's highlights on some of the numbers?
Well, it was an up and down year. I mean, if you had asked me in May what was going on, I would have said there's very, very little activity. And then in the summer, it got very active as the DOJ, for instance, released 4 significant cases in a span of 2 months. And then it got quiet again until, of course, the last week of December when they announced a few more cases. So it's been an up and down. But if you look at it as a year, it's about the same as it has been in other years. There were 17 corporate enforcement actions. The penalties, if you look at the penalties, it's the second highest year, I think, ever for FCPA enforcement. But that, as has been the case in some other years and where they had high penalties, distorts the story to some extent. I mean, if you take out the outliers, the biggest cases which were well above the rest, and the smallest cases which were well below the rest, you wind up with a median or average sanction of about 18 million, 17.9 million. Where if you include the outliers, you have 170.8 million. So this is consistent with what we've seen before. Generally, what we see for FCPA enforcement actions are fines and penalties and disgorgement all taken together in the range of 10 to 25, $30 million. And that's exactly where they've been for years now. And so in terms of the number of cases, it's pretty average. There's perhaps a slight weighting this year toward SEC cases over DOJ. And the SEC cases tend to be smaller in the amount of sanctions. But the SEC was also part of those bigger cases as well, some of those bigger cases.
So one of the things that I found really interesting this year, Philip, and you hit it on it there at the end, is on the SEC cases. I find these in many ways actually more instructive for the compliance practitioner because the SEC puts in its cease and desist orders more detail around the not only what the bribery schemes were, but how controls were overridden, or information that compliance practitioners can really use to either benchmark against their compliance programs or put enhancements into their compliance programs. Is that something that you guys would have observed as well?
Yeah, it is. I mean, I sometimes criticize, and I hear this from my friends at the SEC. I sometimes criticize the SEC for overreaching to reach and charge an anti-bribery count when they don't need it. But where I do find that they have, excuse me, where they have, useful and generally well-supported allegations is in the compliance area. When you see things, when you see cases that really tell you where the company, in the SEC's eyes, went wrong. Examples would be, for instance, in something like the Kinross case, or something like where it was a M&A case, and according to the government, the company knew or learned through its due diligence that the company they were acquiring simply had inadequate and ineffective controls in the anti-corruption area, but didn't do anything after the acquisition. And despite several reports and notice from internal audit, until it just became too big to ignore. And that kind of activities, contrary to the kind of advice that you and I and most of our colleagues probably give companies who are in the midst of an M&A case, which is, if you see something, if you see even if you don't see allegations or specific violations, which is an entirely different story, but if you just see inadequate controls, you need to be prepared on day one. You have to have your day one integration plan to get in there and be able to demonstrate to the government, that you saw the red flags, you identified them, you remediated them as soon as you took over the company, and that gives you a pretty strong leg up when you're talking to the government about violations down the road that crossed over the time of the acquisition.
Let's go to some of the substantive decisions, and one I've really wanted to visit with you about is the Hoskins decision. Whether or not you agree or disagree with the court's reading on Hoskins, I absolutely agree with that it has the potential to alter the scope of FCPA prosecutions. Where that alteration is, though, I think, at least in my mind, is an open question. How do you guys see Hoskins?
I think Hoskins is a very complicated case from a couple different perspectives. But I think, it's interesting because they charged it in so many different ways that they almost had to stumble over themselves in figuring out what they were going to prove, or trying to convince the court what they were going to prove at trial. And, if you start with the DD3, with the section of the FCPA that was added in 98 as a way to reach non-U.S. persons, it has a fairly strong territorial jurisdictional language that is often glossed over in settlements. And this is why cases against individuals become so interesting, because individuals have skin in the game. They're going to go to jail, or at least they're likely to go to jail, and they're more likely, therefore, to challenge the government's theory where a corporation might not, where a corporation might be willing to just move forward and get it over with in some ways. And so here, the language that we put in to the section DD3 in 98 when we recommended to the Congress to amend the FCPA to implement the OECD convention, lifted the language from the previous sections on interstate, use of interstate instrumentalities, But it also said while in the territory of the United States, or to take any other action while in the territory of the United States. And there's a statutory issue there. Is the first clause separate from the second clause? But the court clearly didn't see it that way. And this calls into question a whole bunch of theories that the government has used to bring cases against foreign companies, because very often the theory is causing something to happen in the United States. So if, for instance, a foreign bank, or a foreign company transfers money to another foreign person, but it goes through a correspondent bank in New York, which is a theory that has been alleged back since Siemens. I think Siemens may have been the first case where it was alleged as one of the grounds for jurisdiction, but it's been used fairly regularly since, sometimes in isolation. That theory seems to be somewhat questionable at this point, notwithstanding, a one district court case that held in a civil context that was just a jurisdictional point, as opposed to an element of the crime. But if in fact the company or the person has to be in the United States when they do whatever they do in furtherance of the foreign bribery, the Hoskins case could very much, knock out that idea that correspondent account banking is an act while in the United States. Or if you look at the Magyar Telecom case, that a email that passed through a server in the United States from one foreign person to another foreign person, again, is that an act while in the United States by those persons? So I think that it has a significant possibility of narrowing the ability to bring cases under DD3 against foreign persons. The other aspect, of course, of a Hoskins is the issue of under DD2, where he is an employee of the foreign parent, but he's charged as an agent of the subsidiary. And that, to me, is not as silly as some commentators have suggested it is. It really is going to depend on the facts there. Corporate structures are complicated, but the real question is going to be, is whatever he did he do it, for the benefit of the subsidiary in a way that the government can prove to the jury's satisfaction, and ultimately the court, that he acted as the subsidiary's agent? There is not the same jurisdictional requirements as in DD3.
So I had the chance to visit with a former fraud section prosecutor on this case.
Well, I'm a former fraud section prosecutor also.
All right. Well, that's great. And I asked her, I said, what would be the law? Typically agent principal relationship is a state law question. And if there's no federal law on that, would it be the law of the circuit that would make that determination? And if that's correct, could we have 11 different legal precedents in 11 different circuits?
Yes, I think the answer to that could be yes. There's no definition in the FCPA as to what an agent is, but the DOJ has historically not taken agent to mean to apply the narrowest technical definition of agent. They apply a rule of agent in fact as opposed to an appointed agent. So similarly to if you're talking about corporate liability, I'm not sure it's going to make that much difference, because in that case where you talk about a person who's acting within the scope of their duties and for the at least in part for the benefit of the corporation, I think it's a hard if a person is acting for your benefit, I think generally the DOJ is not going to, and they may lose at court if you go to court, but I don't think that they're going to take a particularly technical view of what an agent is in that context. Of course, if you're the individual being charged as the agent, absolutely would expect them to make that argument.
So you also note, in addition to the decision having the potential at least alter the scope of FCPA prosecutions, that it potentially could alter the scope of the investigative process. Would that include the internal investigative process as well?
I don't know that any of this is going to change the internal investigative process, quite frankly. I mean, these kind of decisions, are you an agent? Did you do an act within the territory of the while in the territory of the United States? If you're a corporate compliance officer or a general counsel faced with or an audit committee member faced with an allegation that someone associated with the company in some way might have done something wrong, jurisdiction isn't going to be, your deciding factor. You're going to go forward and do, or you should anyhow, go forward and do an effective, credible investigation, thorough investigation, because it's not just the anti-bribery provisions of the FCPA that's going to concern you. Even and remember, Hoskins is really mostly an issue for foreign companies and foreign individuals, not for U.S. companies and U.S. individuals. But even if you're a foreign company, if you get that kind of allegation and you have enough of a nexus with the United States to be at risk, I think you do the investigation, because things happen. I mean, things pop up, odd little transactions pop up, or travel pops up that all of a sudden the government has enough of a hook for a jurisdiction. And if you're a foreign company that's an issuer, or have a shareholder, a substantial shareholder who's an issuer, who itself might have it be viewed as having risk, you're going to have to be aware of the SEC and the DOJ on the books and records side. And then you add on to that if you're a foreign company that has a presence in the UK and whatever a substantial connection to the UK means under the Bribery Act, you have a risk there. And they have the concept of associated person, which sort of takes you out of the agency law question that we were just talking about. And then we're seeing more and more enforcement actions just elsewhere. This year, for instance, we saw one of the first cases that actually involved, public and active prosecution by the French authorities of one of their own companies in a bribery case. Germany has been active. Italy has been active. Brazil has been active, and we're seeing as an offshoot of Lava Jato, more and more corruption investigations in South America. So the risk of enforcement is not just here; it's worldwide. And I think if you have an allegation, you're not going to be laser focused on the elements of the FCPA in determining whether to conduct an internal investigation.
So the French case you mentioned that you touched on earlier, Société Générale, do you or does the firm see that as possibly heralding the emergence of France as an important global anti-corruption authority, investigator, and enforcement location?
Well, it would be about time if they were. It's hard to say. I mean, I've had a lot of fun making fun of France, for many years. Difficulty sometimes with civil law countries in general is knowing what they've charged, who they've charged, and what the ultimate result was. What we're seeing in France, though, is a bit of convergence. The establishment of a DPA system, which they never had before, the public announcement of a case against one of their national champions, in this case, is significant. It's a significant development that has been, too long in the offing, quite frankly. That one of the reasons why, in my view, the DOJ in particular has brought cases that greatly expanded, perhaps beyond the scope of the statute, the provisions of DD3, and is because they were concerned that there was not enough of a political and governmental will to bring cases in countries such as France. I mean, if you look at the history of FCPA enforcement, you'll see a lot of cases against French companies where the jurisdiction isn't always. Sometimes it was clearer than others. But it was clear to me, although I'm not sure my colleagues would admit it, that the DOJ really stretched to reach companies in countries where they felt that there was not a sufficient enforcement regime. And this may be an evidence that France is the French prosecutors anyhow have caught the bug, and they realize that there's merit in these cases, both from enforcing the law, which they've.
So one of the other highlights from 2018 noted in the report was really the continuing trend of updating various enforcement policies. I would even maybe step back to late November 2017, where we had the announcement of the new FCPA corporate enforcement policy. But certainly in 2018, in May, we saw the anti-piling on policy. In July, there was a policy incorporating mergers and acquisitions safe harbor into the new corporate enforcement policy. Then we had in October an updated policy on corporate monitors. And finally, in late November, Rod Rosenstein announced some slight changes, or some changes, I should say, to the Yates memo. How do you see all of that playing out?
Oh, no, there's two parts of this. One is an effort to align policy with practice. So where I see in the no piling on policy from earlier this year, or the modifications to the Yates memo, which is now in the U.S. Attorney's Manual, and to some extent in the monitorship memo, is really an effort to say, look, this is what we do. And if we have previous policy documents out there that don't, completely conform to this, we want to make sure that they do align. And the Yates memo had almost a binary approach to cooperation. Either you give us everything and everyone, or you're not, or you don't get cooperation credit. What the changes recognize is that sometimes the corporation just can't, either because it's prohibited by foreign law, data protection, or bank secrecy, or because the evidence just isn't there to get down to the to the person with the bag man. If you give as much as you can, you ought to get cooperation credit. And that's what I think they recognize now. It doesn't mean that, it's clear to me that this is not from a compliance proposition, or from a defense counsel or a corporate counsel conducting investigation, that you get to choose what you give the government. The government still expects you to give everything that you have, that you're permitted to give, and they'll make the decision: is this someone who had a substantive involvement? Is this a person we want to charge or can charge? It's not that you get to make that decision. So I don't think that those changes are actually that significant. I think it just reflects practice that sometimes the government, a company just can't do everything, and the government understands that. And they modified, some of the language in what was the Yates memo to reflect that. The no piling on part, this is an issue, we've argued with government in a number of cases, and I think that they do take the position. They do believe that they are fair in their determination of penalties and how they share them. And certainly, we've seen sharing of penalties with other agencies, crediting, often even with foreign enforcement agencies, such as in the Odebrecht and Braskem cases, and in the Petrobras case, where the government will determine a fine, but then credit a penalty that's paid to the Brazilian authorities, or the Dutch authorities, or so on, or the French authorities. What the no piling on policy says is, that's what we should be doing. The problem, of course, is if you're in a case that has multiple agencies, is it really a fair allocation? Are they going to credit all penalties paid to all other agencies, and how do they decide who gets to keep what? What no piling on ought to mean is that if there is another agency with equal equity in a matter, or even greater equity in a matter, should the DOJ stand down and let that other agency, or that other enforcement authority, or another foreign country really do the case, even if that means that the DOJ doesn't get a stat, or they don't get any fines. And that's the kind of thing that the policy leaves lots of room for the government to move. It's not a determinative policy in the sense that you can just plug things in and get an outcome. It's still discretionary at the government level, at the DOJ level.
What I wanted to end, Philip, was asking you: were there really any other general trends, or anything else from sort of 2018 that stuck out for you that you think will be significant moving forward?
Quite frankly, I didn't see 2018 as like a watershed year. What was interesting is that it fits and starts, but they got there at the end. They got their numbers back up. They certainly did some large cases in the middle. And that may be indicative of where 2019 is going to go. I think, my analysis, my, reading of the tea leaves has been that the drop in cases over the past couple of years was more a reflection of the lack of congressionally confirmed executives at the DOJ and elsewhere that made it more difficult to get the cases approved, settlements approved, because you had people in acting positions and people who were, sort of reluctant to take steps, knowing that there was someone coming down the road who eventually would be confirmed and would want to be in a position to make decisions. I think at this point, with the criminal division having a confirmed AAG, more people being confirmed in their positions, either or made permanent rather than acting, I think some of that flow is going to start up again, and we're going to see more cases coming out of the DOJ in the next year. I did read recently that someone from the SEC, was commenting that their head count's down, and therefore they were going to focus their resources on particular types of individuals, such as gatekeepers, attorneys, accountants, financial officers. So all of that, to me, indicates that 2019 may be a very interesting year, perhaps more interesting than 2018.
The things that I've observed, and I wanted to ask you, from your perspective, as both a former prosecutor in the fraud section and in private practice for some time, is that certainly with some of the updated policy changes we saw this year that align more with the practice, I see the department really, I don't know if listening to people is the right word, but or the right phrase, but I see them making adjustments to policies and procedures that people like you and I would talk about. And I would, in addition to the piling on or anti-piling on, the safe harbor for mergers and acquisitions, that was first brought up in the 2012 FCPA guidance. And I think people were really concerned about potentially buying an FCPA violation, and the DOJ laid out a way to ameliorate that concern. And now they've put the mergers and acquisition under the new corporate enforcement policy. Do you have that same sort of observation, or is it something different?
No, I do have that. I agree with you. I think those of us, regardless of our political stripes, have who have been on the dark side for since we left the government, and those who never were in the government, have been critical of some decisions made by the DOJ. That seem to be, perhaps just bringing a corporate case where you would have to ask yourself, well, what should the corporation have done? If it did effective due diligence before a merger, but people lied to it, or it just didn't find it because it wasn't, it was an isolated case. But then you find it afterwards. What exactly are you punishing the corporation for? I mean, there's no question in my mind that you should. That it's not a question of a legal defense that you bought a new company and therefore there's no liability that carries over from the old company. I mean, that'd be just too much of a loophole for extinguishing liability. But if you have a company that did good faith work and just inherited a problem, bought a case, then there ought to be some way that you recognize that. And I think that's what, we had criticized DOJ and the SEC to some extent for not recognizing reality, just sort of putting on 20/20 hindsight and saying, oops, well, you got it, you got to pay for it. I think there is a tone within this administration that that tends to focus more on being business friendly and emphasizes the parts of the policies that were already in place and emphasize, as to that the ultimate detriment, effective deterrent is to prosecute individuals. And therefore you see things like, I think, the FCPA corporate prosecution policy, which, grew out of the previous pilot program. But you see the no piling on, you see more of a acknowledgement in the monitor memo that companies may not need a monitor if they've demonstrated that they learned their lesson and are implementing controls on their own, and then in the Yates memo or the amendments to the Yates memo, I think there's an overall tone today there's a pendulum that swings back and forth between the corporation, going after corporations and getting big fines and using that as the way to change corporate culture, and individuals saying, look, the individuals are the ones who acted with criminal intent and they should be prosecuted. From the original Holder memo, we always insisted you got to do both. And that's been the consistent policy of the department ever since. But, over time, administration to administration, assistant attorney general to assistant attorney general, fraud section chief to fraud section chief, you see, more of an emphasis one way or the other. And I think definitely in this administration, although the department is not, averse to getting a big fine in an appropriate case, they say there does seem to be more of an emphasis on getting the evidence and being able to prosecute the individuals.
Well, Philip, as always, this has just been a fascinating discussion for me. Once again, thank you and the firm for putting out the digest. We're going to link to the digest and the new site in our show notes, and frankly, look forward to continuing the conversation.
Well, you're very welcome, and we'll talk again in 6 months or a year, I'm sure.
Hello, everyone. This is Tom Fox again. I hope you've enjoyed this episode of the FCPA Compliance Report. We're going to link to the Shearman Sterling 2019 FCPA Digest, as well as its more comprehensive complete digest in the show notes. So check those out. I know you'll find them interesting. I hope you'll join me again next week, where we have another FCPA compliance-related topic. This podcast, the FCPA Compliance Report, is a part of the Compliance Podcast Network.